Mr. Deputy Speaker, sir, I declare my interest as a practicing lawyer who occasionally handles criminal cases. Given Singapore's position as a major financial hub and the greater push towards digitization of our financial services and banking industry, Singapore is vulnerable to criminals who exploit our financial systems to make illicit gains. Singapore is not unique in this regard. There has been a trend of rising economic crime worldwide. In response to a parliamentary question that I filed last month on economic crimes in Singapore, the Honourable Minister for Home Affairs stated that the number of commercial crimes reported in Singapore had remained stable over the last 3 years from 2015 to 2017. However, in the PwC's Global Economic Crime and Fraud Survey 2018, PwC noted that its findings of a sharp increase and a record high of reported economic crime in Singapore, which is consistent with the global trend. In particular, according to the PwC survey, more than one-third of Singapore-based organizations experienced economic crime, up from 22% in 2016. The Honourable Attorney General noted in his keynote address at the 36th Cambridge International Symposium on Economic Crime earlier this year that while our domestic crime rate remains low, Singapore's exposure to transnational economic crime is on the rise. The amount of foreign illicit funds, he says, seized by the CAD in 2016 amounted to around Singapore $164.5 million. This is a nearly five-fold increase from the previous year in 2015. Given the increase in both the extent and sophistication of transnational economic crime syndicates, I fully support the bill, which seeks to enhance the law enforcement agency's abilities to seize assets from illicit activities and deter criminals by taking the profit out of their crimes. In this regard, I beg to differ with the opinion expressed by the Honourable Member of Parliament, Ms. Sylvia Lim, who postulated a question as to whether this bill throws up purported inadequacies in the current regime by reference to the 1MDB case. As a private practitioner, it seems to me that actually the 1MDB case shows the efficacy of the regime as it stands now. Singapore, ahead of other jurisdictions, has prosecuted and secured convictions of perpetrators. Not only that, 2 banks were closed down as a result of quick action by the relevant law enforcement authorities. Not only that, recently FATF has given Singapore, after a mutual evaluation, a clean bill of health. So this shows that the regime works, but we are faced with a dynamic situation, not a static situation, and it's entirely appropriate for the Honourable Minister to highlight that given the inventiveness of these criminals, we need to constantly check to see whether or not the measures we have are adequate. And in this regard, I have a few suggestions. The bill provides for the public prosecutor to apply to court to make a confiscation order against monies that a person has moved in or out of Singapore in contravention of Section 48C or 48D of CDSA. This, as well as confiscation powers under Section 4 and 5 of CDSA, only applies after the accused is convicted of the offence. By then, it may be too late, as the monies may have been dissipated by the accused. These provisions will have bite if assets are frozen at the outset and the confiscation order is then applied against the frozen assets. There could be situations where assets from ill-gotten gains are in Singapore, given that it's a prominent international financial center, but the perpetrators may not be here. Hence, the prosecution, much less convictions, are not contemplated. Yet there's a compelling case to seize and confiscate such monies too. As the Honourable Minister mentioned, these activities can have the impact of destroying our reputation as a trusted global financial center. I would suggest that we consider having civil seizure and confiscation provisions prior to or in parallel with criminal proceedings. The Organised Crime Act has such provisions. The Act, which was introduced in 2016, allows for confiscation without the need for criminal conviction where a person carries out a serious offense at the direction of an organized criminal group. Serious offenses include the various offenses under the CDSA, such as assisting to retain, acquiring, possessing, or transferring benefits of criminal conduct. However, the Organized Crime Act, as the name implies, requires the prosecutor to prove that the accused knew or had reasonable grounds to believe that he or she was acting in accordance with the direction of an organized criminal group. Hence, the ambit is fairly narrow, providing for a wider civil-based freezing and confiscation regime under the CDSA would give the law enforcement agencies more teeth. As a parallel, the USA has a civil forfeiture regime in place which allows law enforcement officers to take assets from persons suspected of involvement in crime without necessarily charging them for wrongdoing. Australia also has similar legislation which allows for civil-based recovery. Such civil-based recovery allows restraint and recovery of assets suspected of criminal origins without the necessity of securing a criminal conviction. The UK has additionally introduced an unexplained wealth order civil-based regime whereby, independent of a conviction in a criminal court, a person's assets may be seized and confiscated in favor of the government if he or she is unable to explain the disparity between his known sources of wealth and the value of his assets. The UK Law Commission has recently embarked on a 2-year project to review its laws on confiscation to ensure effective recovery of the proceeds of crime, which is presently in the pre-consultation stage. The review will focus on whether the present conviction-based confiscation regime is sufficient and what improvements could be made. Specifically, it is consulting on a proposal whereby a person who is charged in court for an economic crime is also visited with a freezing order of his assets amounting to the same amount that is alleged to have gained from the economic crime. It is typical, in the words of Professor Michael Levy, a very well-known criminology professor, that criminals in such situations often claim that they have spent all their ill-gotten gains on fast women and slow horses. Clearly, though, they should not be taken at face value. We should ensure that we have sufficient tools to combat economic crimes, in particular by depriving criminals of their ill-gotten gains. In this regard, and in light of the global trends, I have 3 suggestions. A, providing for an increase in punishment or some punitive measure against a criminal if the confiscation order made against him is not satisfied. There's already a trend in the UK of unsatisfied confiscation orders. Such paper judgments cannot deter people from committing economic crimes. What we don't want is for criminals to go to jail at the expense of the people, come out and then connect with the monies that they've stolen later. B, providing resources to our authorities to chase after the assets of criminals in other countries. It should not stop at invoking MLATs, that's mutual legal aid treaties. If necessary, there should be civil actions taken to recover the proceeds. C, at the point of charging a person for an economic crime, if he has unexplained wealth in his name, even though it cannot be specifically traced to the crime in question, the authorities should consider commencing money laundering prosecution in parallel so that the unexplained wealth may be frozen pending the outcome of the criminal proceedings. This will allow the confiscation order that may be made subsequently in the event of a conviction to have more bite. In my parliamentary question last month on economic crimes, I asked for the total value of assets misappropriated or gained by offenders who have been convicted for economic crimes in Singapore, in contrast with the total values of assets recovered by the authorities. The response from the ministry was that Singapore does not track such data. With respect, we should. Without tracking such data, we may not be able to monitor the effectiveness of our confiscation regime to track our progress on this front. Separately, I would ask, how would the confiscation orders work in the context of co-accused persons? Would they be jointly or severally liable in respect of the confiscation orders? Moving on, in respect of the proposed amendment to allow for exchange of information under international arrangements, I note from the Honourable Minister's speech that this would include the Egmont Group of financial intelligence units. Apart from this, what other international arrangements are contemplated, and would such international arrangements be disclosed? In conclusion, I would like to highlight the Honourable Attorney General's speech at the Cambridge Symposium, where he described Singapore's approach to combating economic crime as a 3D approach: detection, deterrence, and deprivation. The confiscation provisions in the bill specifically focus on the final D, deprivation. My suggestions are made in the context of focusing also on the first two Ds, getting the authorities to detect the extent of a criminal's wealth, and as well as providing some teeth to deter like-minded offenders. As criminals constantly revamp their methods to evade detection and law, we too must constantly evaluate our means to guard against them or deter such behavior. I support the bill, which is in step with our efforts to ensure that Singapore is not seen as an easy target for our criminals. Thank you.